to go if you are.
Great. So a very warm welcome to all the participants here. It's truly an honor to host Professor Wessels. Professor Bob Wessels is a name that needs no introduction to insolvency regime in any part of the globe. He has been Emeritus Professor of International Insolvency Laws, University of Leiden, Leiden Law School in Netherlands. And prior to this, he was also Professor of Civil and Commercial Laws at Rijks University in Amsterdam. Professor Wessels holds 45 years of business law experience, including 13 years as a partner of a law firm in Amsterdam and London, including global managerial functions. Since 2005, he has had his own independent international practice, and he has acted like expert witness for over 10 non-Dutch courts and international arbitrator. It's my pleasure to share with you that on matter of business rescue and insolvency, he has served as consultants to IMF Indonesia, World Bank in Georgia, and to the Dutch Ministry of Justice. Professor Wessels has published over hundreds of articles in leading legal journals and over 25 books, 7 of which has been written in English with professors, judges, or insolvency experts across the globe. He has several visiting professorships, and since 1995, he has only been working as a part-time professor, and he retired from academia in 2014, but I'm certain that his guidance and mentorship will continue towards various institutes across the globe. And I also must make a mention that he's one of the tallest figures in insolvency, which has helped several jurisdictions to shape up their laws, reading his scholarship in various journals. Thank you so much, Professor Wessels, for agreeing to do this session with us. And I really hope that audience will have a lot of questions from you towards the end. Thank you so much.
Okay, thank you very much for this very broad introduction. Some of the new items, the items you told me are new for me myself, that I lost them in my head. But the one thing you didn't mention is the most important year in my life, which is 1974. 1974. That was the year I earned my first salary as a lawyer. So that's the 45 years. If you can assist me now by showing me the slides. Yes. And we agreed that you would assist me when I ask you to put forward the next slide. I'm just asking you to do so. Yes, thank you very much. Well, I'd like to stress, of course, that I'm presenting a non-Indian view on the design of a cross-border insolvency regime. I do so also because since around a year, I'm a member of a small working party, again in the Netherlands, after 20 years retrying to design again in the Netherlands a cross-border insolvency regime. So we are roughly on the same level of development of legislation to deal with outbound and inbound insolvency cases. Next slide, please. So the themes of today's are, you can show them all. What are the problems? What have been done so far in your country, but also in mine, to respond to these problems? What are the topics that we should set now to try to regulate? Can we make a division between short-term topics and on the longer term? The other theme is, can we do this with all legislation? Or could we also use, as an alternative, soft laws or principles or guidances? And the last question is, are there some sources that India could use in trying to devise the present ideas with regard to cross-border insolvency. Next slide, please. Yeah, thank you. Well, this is first question. What are the problems? Well, I refer to my dear friend and colleague, Professor Fletcher, who passed away 2 years ago, and he wrote, national attitudes towards the phenomenon of insolvency are extremely variable, as are the social and legal consequences for the debtors concerned. So all national legislations are dealing in their own way with insolvency and also in their own way with cross-border insolvency. Now let me take you to the IER, this is the European Insolvency Regulation. And a regulation in Europe means it is approved in Brussels with the influence of member states, but the regulation itself binds national countries automatically. And if you go to recital 22 of the regulation of 2015, you see that it is acknowledged that the fact as a result of widely differing substantial law, it's not practical to introduce, etc., etc. And that same recital was already there 15 years ago. So only from those two lines, you get the idea that in the last 15 or 17 years, national legal systems of the 25 or 6 or 7 countries in Europe are still the same. There's hardly any development. Next slide, please. So on the one hand, you see immense growing of global business, and global business has to deal with still very national type of legislation. And that gives you the examples of the problems that you will meet and that you have to deal with in any regulation that you'd like to include in your own country. Are the assets of a company located abroad or not? Do we have, for instance, as a Dutch company, are there foreign shareholders? Or if there's an Indian insolvency practitioner or an RP, does it has also powers in our national jurisdiction or in the Polish jurisdiction or the Japan jurisdiction, wherever countries you are? Can we deal with foreign creditors and what type of documents have they present to allow them to file their claim and to have their claim verified? How do we deal with groups of companies? Short answer, we hardly don't, but nevertheless, it is an element of global business to deal with groups of companies, and there is no typical legal answer for that. Next slide, please. You can show all, yes. Well, from history onward, some 100 years, typically the approaches are two of a kind. First of all, universality or universalism. So let's have this Indian company that goes bust in India, but it has assets in several states, including the Netherlands and in the US. Universality would mean that all the assets in the US and in the Netherlands would be included in the estate in India. And the lex concursus, which is the former Latin name of the law of the countries where the creditors are concurring, that law applies, which is in the universality system, Indian law. So Indian law then would also apply in the Netherlands and in the US. Well, you can imagine that not everyone is in favor for such an approach. The other approach is territoriality. Territoriality means we all have our own system. We have the Dutch system, the US system, the Indian system, and all those systems apply the lex concursus. So the law of the US, the law of the Netherlands, and law in India in their insolvencies. Next slide, please. Universality as I gave the example, as a big advantage. You treat creditors in the US, in the Netherlands, and in India alike. There's an efficient administration, probably of one estate. You can predict the outcomes of it, and you avoid costs, not having procedures in several countries. The disadvantages, of course, are that a global application of Indian law on a contract where we have a Dutch party and in the contract it says Dutch law will apply or Swiss law will apply, there will be conflicts of law. So typically complex choice of law questions. And on the other hand, what I remember from, as was referred to, in Indonesia 25 years ago, the Dutch law was applied because Indonesia at that time, some 50 years ago, was a colony of the Netherlands. The efficient, typically direct approach that the Dutch have and also their laws have didn't fit into the Indonesian culture whatsoever. So if you have a universality system, you also export the social and legal values of your country to other countries where there will be different attitudes for welcoming those values. Next slide, please. Well, the other hand is territoriality is very simple. You apply national law of all countries where you have assets or creditors or whatever. There's no influence from other systems, and a creditor in the Netherlands would expect, if there are Indian assets from an Indian company that is abroad, that the Dutch law would apply. So probably not so much for very sophisticated creditors, but general trade creditors would expect that their national law will apply. The disadvantages are easy. It's what Professor Westbrook called the grab rule, or in German it's the Raubsystem, robbery. So every national country, you can go to the most valuable assets and try to get your hands on it. If you have these three countries in India, the Netherlands, and the US, there will be three proceedings. Inefficiency, costs. It may encourage forum shopping, that the Dutch creditor would say, well, I will try to get my hands on the assets that are in the US. That is much more in my advantage. And most probably, if you apply national systems, it will break through international credit finance patterns. Next slide, please. Well, in one slide, I tried to capture some 200 pages of literature. The other perspective is not so much with an angle into a state, but is contractualism from the American professor Rasmussen or the German professor Eidenmüller. Contractualism means in your articles of association as a company, you take the law that you would apply when there are creditors dealing with your company. For instance, there is a Dutch company. If you know you have a lot of creditors, future creditors in Spain, it is a possibility that you would say in your articles of association, well, in case of insolvency or bankruptcy, we will apply Spanish law on the basis of our contract. That is comfortable for the Spaniards and also comfortable probably for the Dutch, because you can relate to that law. Contractualism is a fine system in theory, but it hasn't found any support in countries. Then there are mixed territoriality systems or universality systems. If you have the three proceedings in India, in the Netherlands, and the US, would it be possible, for instance, for the the Indian insolvency practitioner to give a promise to the Dutch creditors saying, I will treat you as if Dutch law would apply, but please don't open proceedings in the Netherlands. And that is what it's called synthetic proceedings, the Dutch proceedings. Don't open formally, but the creditors are treated as if the Dutch proceedings would apply. Well, these synthetic proceedings have been included in the European Insolvency Regulation, but we only, since some 3 or 4 years, have found one case in Germany and Austria where synthetic proceedings have been applied. In practice, you see a mix of universality and territoriality. Next slide, please. There's a new tendency to say, well, what's the role of the state in it? Why are we devising a system that is so strongly coupled, integrated into the ideas and policies of a state? So there's a shift from state-led practices, what a French author called a déthéoratisation. I try my best French. So we should devise a theory which is not related to a state. And some 12 years ago, my idea was based on my own practice, of course, with many of the practitioners in the world. We should go for cross-border cooperation, and in the end, a convention should act as an aid for judges, etc. The convention idea has not been taken up because every time the idea is national governments will put their head in the sand or will not be in favor of passing on certain powers that they have to the idea of a convention. Next slide, please. Yes. So now, as I said, I start my basis as the Dutch are some sort of in a mess. Of course, Indian legislation is not in a mess, but we are in the same system of development. The Dutch had, the last 10 years, large international insolvency cases. There was the Yukos case, the large oil giant from Russia, but the largest telecom company from Brazil. And there was a smaller case, which you are much more familiar with is the Jet Air India case. We didn't have any regulation, so what are the consequences? If you are a legislator, you have to think about what are the consequences and how are we going to deal with improving the system. First of all, uncertainty in advising to people, to businesses, because you cannot anticipate on any rules because there are no rules. There's long-term legal uncertainty whether if the proceedings are opened in a third country would be recognized in our country. There will be additional costs for legal opinions. There will be costs because there will be proceedings or similar type of measures in the case that I gave in India, in the Netherlands, in the US. Presently, you see in many countries a tendency to go to restructuring regimes based on an agreement, collective agreement, or certain private settlements. We still don't know yet for the Netherlands, but also for in many other countries, whether these will be proceedings or similar type of measures that will be recognized. And of course, if you have a small business and a mom and pop shop, they can hardly deal with international issues because of the high costs and the long patience that you many times will have to have, because 5 or 7 years is rather short in an international case. Next slide, please. So the policy issues. What does it mean if a legislator is not dealing with international insolvency law? The legislator is seen as to be non-competent. I didn't make any friends in The Hague last November when I was there for the last time because of Corona. We couldn't continue with our work in this small working party that we have. But the legislator is seen as non-competent in dealing with what global business is already dealing with for 20 or 25 years. The legal framework that we have in the Netherlands is weak. And as business is a part of the global community, it's a sign with your weak system that the national legislator is not a part of the global community. But the IPs and in general the courts, at least in the Netherlands, not all countries are on the same quality and sophistication. The IPs and the courts in general are dealing with global issues. Now, I know that one of the topics of debate in India has been, shouldn't we have a provision on reciprocity? Meaning, if we want the Dutch insolvency proceedings or the American insolvency proceedings, allow them to come to India, they have also allow Indian proceedings to come to the Netherlands and to the US. Now, we will talk about the model law of Untitled a bit later, but in Argentina, in South Africa, in Mexico, in Romania, reciprocity has been taken on board. Nevertheless, that the model law, as we will see later, is not in favor of having reciprocity. Also in Switzerland, which is also always a neutral country, has a reciprocity provision. I'm always wondering why a government says we can only allow an American or a Dutch proceeding to come to our country when they recognize our proceedings in a similar way. What's the justification for a state to bring that forward? What's there to protect for that state? You always can build in matters of provisions of public policy or so, but in general, just closing the door for outside insolvency proceedings based on the sole element that, well, they don't recognize our insolvency proceedings, so we don't recognize theirs, is not a very strong position. Next slide, please. Dr. Shika, thank you very much. Now, I will show you some 5 or 6 slides very quickly, because maybe some of you are dealing with a paper or assisting the legislator or whatever you are doing. What are the topics, also in the Netherlands, that we have to cover if we want to build a rather broad and good international insolvency system? A regulation of international insolvency law must in any case address the themes of the scope of the regulation. Will it include, for instance, insolvency proceedings for bank and insurers? Next slide, please. The recognition of insolvency proceedings opened in third countries, so in other countries. Who is the competent person to file for a recognition request? Who is the judge in your own country that deals with the request? What's the assessment framework to deal with those recognition requests? Next slide, please. The declaration by the home country with regard to protective measures, which you many times see in practice. You want to have a swift cooling off or stay position. The questions that you have to deal with there, if they are opened in third countries. I listed a few of those questions there. Next slide, please. Yeah, the yes or no automatic effects of the recognition of insolvency proceedings opened in those third countries. Again, you have the same questions I dealt with earlier. For instance, the exercise of the power of a foreign IP. Does he need approval if the Indian IP would come to the Netherlands? Approval from a judge in the Netherlands? Which judge? Because our very small country, it's about 100 kilometers broad and about 200 kilometers high. We have 11 courts dealing with these matters. And then, of course, between the courts, you have to struggle about the competence in our very small territory. Next one, please. And again, the declaration of protective measures by the home court after the recognition, it's opened in second countries. You have to take these, slides and copy them, for instance, if you are trying to regulate. Also, if you include the model law or larger part of the model law in your country, then probably in national law, you have to have additional rules with regard to the more detailed questions as you just showed you in the last 4 or 5 slides. Next one, please. Okay, what type of regulation? First of all, insolvency law itself on a national level is always complex because you have to deal and try to align typically different angles of interest. International insolvency law is even more problematic. Legislation and international legislation is a very slow process. So the only tool we have is a tool that works very slow. That doesn't work in cross-border business. Then we have the politicians. I know the name of one politician, I think in India. I know about 200 names of the politicians here in this very large country that we have. There is no political party in the Netherlands whatsoever that has changes in the insolvency law in its list of the top 10 priorities to deal with in government. So for politicians, insolvency law is hardly an issue. So therefore, maybe also in governmental regulation, you see the last 10 or 12 or 15 years, many times there are guidances, recommendations, guidelines, principles on whatever issues. Maybe they're building a system of regulatory ideas of practice and judges that sit together as an alternative. Next slide, please. Well, there are forms of regulation, hard law, so in legislation. You have bilateral between 2 countries and regional legislation. On the bilateral front, and on the unilateral front is a country saying, I am dealing with international insolvency by myself without any agreement with another country. You had Section 304 of the US Bankruptcy Code 15 years ago, where the bankruptcy courts in the US would say, we will recognize anyone with a proceeding coming from abroad based on comity, on the basis of giving respect for another country and its proceedings if it matches the ideas that we have here in the US. A larger unilateral approach is Section 426 in the UK Insolvency Act of 1986. There you have some 15 or 18 relevant countries in which court give assistance. The UK court give assistance. Those relevant countries, especially in our area of the world, are called the cricket-loving countries. So they used to be a part of the very large kingdom, the very large Great Britain. But these are the only unilateral, there may be one or two others, but these are the larger unilateral approaches to cross-border insolvency. Then there are bilateral measures. In as far as you didn't know, the Netherlands, the southern border of the Netherlands is a country called Belgium. And on the eastern border, there is a country called Germany. And in 1926 and 1963, there were bilateral agreements or conventions with those two countries dealing also, not with arbitration or other methods, but also including insolvencies. But if you go to the present Article 85 of the European Insolvency Regulation, the regulation has come into force and those treaties don't have effect anymore. There are about some 30 treaties between France and Italy and between Poland and whatever country. And now we have this European system. But if you go to Asia, for instance, it's very interesting to see what I saw, let's say, last year. You see courts, for instance, in Singapore, trying to come to an arrangement with the US court in Delaware and the Southern districts in New York, in a way of, if we have a case that involves the Singaporean judge and the New York judge or the court in Delaware, let's try to arrange our communication in a way as we will agree. I will show you the document later. And I learned a few months ago that the court in Seoul has the same type of arrangements with the court in Singapore and in New York. So here you see some sort of bilateral regulation, not dealt with by the government, but by courts themselves. It's a very active and proactive position. Next slide, please. On the regional front, there are some conventions and treaties in Latin America. They're already 60 or 80 years old. There's the Nordic Bankruptcy Convention between the 3 or 4 Scandinavian countries, which is the northern part of Europe, the Convention of 1933. As a regional regime, there is the North American Free Trade Association, NAFTA, between Mexico, Canada, and the US, but that only in practice deals with cross-border communication, mainly between the Americans and Canada, because of the ease of language. Then in Africa, you have the OHADA, the Organisation de Harmonisation de Droit, something meaning the harmonization of business law in some 18 or 20 of the African states. And this is a rather well-developed regional insolvency system. So you have the EU insolvency regulation system. Thank you, Paul. Droit des affaires, business law. And in Asia, there is presently not a regional regime, even if it is very light touched. The countries are still on their own. Next slide, please. So we go to soft law, meaning organizations that have a rather good reputation, that work together with the expertise and experience of IPs and judges and academics, work on something that looks like legislation, but of course is not legislation because the outcome of their work is legally non-binding. And there are different categories. International standard setting organizations like from the United Nations and from the World Bank, global and regional, local standard setting institutes like the International Insolvency Institute, Insol International, and remarkably also the Asian Business Law Institute, which is there since some 4 or 5 years, and informal standard setters, working groups, for instance, on the communication and cooperation guidelines between practitioners. Practitioners sat together of 20 countries in Europe and said, let's try to regulate our behavior when we communicate with each other. Next slide. Yeah, let me just take you to one of the examples, which is the American Law Institute and the International Insolvency Institute III project on global principles for cooperation in international insolvency cases. It ran, I've written the report together with Professor Ian Fletcher. We've written a report, and Paul Omar was assisting us also in the very early years, I remember, between 2006 and 2012. The general idea was, in NAFTA, Mexico, Canada, and the US, there were principles of cross-border communication or court-to-court communication. And the question posed to us was, can we apply those rules on a worldwide basis? Would the whole world, Japan, the Netherlands, Bolivia, etc., accept the principles that we arranged? Well, what Professor Fletcher and I did, we refined them with a very large group with questionnaires. We also had to build in a glossary of terms, because then for the first time you learn that if you use the word cooling off period or stay, or even the word creditor, doesn't have the same meaning in all countries around the world. So we have to create our own terminology there. And we gave recommendations for the recommendation and recommendations on applicable law. Next slide, please. I think you see the website where you can find it. So now to those who are very skeptical about soft law. If you go to the London High Court, the Chancery Guide of October 2017, it has, a large book on how do we deal with cases, but also cases with cross-border effect. Then you see in paragraph 25, the court-to-court communication is dealt with, and then next slide, please. There are at present 3 principal sets of guidelines for court-to-court communications. It might be adopted. And the guidelines are the guidelines from Fletcher and me, from the American Law Institute and III. I just call them for fun, guidelines from me. The EU guidelines that have been approved with a project, again, with Dr. Paul Omar, I think in 2015 or 16. And some 2 years later, the GIN guidelines. And the GIN guidelines on the initiative of the court in Singapore have been developed about communication between courts from Singapore and other courts that underwrite those guidelines. Next slide, please. Yes. And the last line in the Chancery Guide says, of course, 2532, in cross-border insolvency cases, one should consider at an early stage in the proceedings whether the court should be invited to adopt one of these sets of guidelines for use in the proceedings with such modifications as the circumstances in the case may require. So the court itself is totally sovereign to deal with it, can bring in, the judge can work in it all the modification that it wants. Now, a month ago, the Grand Court in Cayman had to deal with a protocol in the matter of LATAM Finance. And LATAM is an aircraft company. It has the jurisdictions involved where the US I think it was what we call Chile, Santiago, and Colombia. And the parties, we'll talk about it later, made a protocol how to deal also with courts. And there the court says the practice direction and the ALI-III guidelines and the GIN guidelines may be viewed as emerging sources of law which have been described as soft law in an article from Leiden researcher Gert-Jan Boon and me, which is published, I lost the source where, but you can find it. It is these instruments, the court says, that most directly provide a jurisdictional basis for approving the protocol, building on a more substantive common law principle mandating assisting foreign insolvency courts as far as possible in the inherent jurisdiction of the Grand Court to manage its own process. So you can call it non-binding soft law, but is nearly as hard binding as, let's say, normal law, at least for this court, at least in the given circumstances. Next slide, please. Now, I know, and many other countries know it also, that Uncital, the United Nations Committee on International Trade Law, has already, next slide please, has already made a model law. Please continue with the slide. This is a general idea of what Uncital, it's not a public organization, but it is dealing with commercial laws. Next slide, please. It created a model law. It took only 3 or 4 years for the persons involved to draft a model law of 32 articles. It has 4 main legal topics. I'm not dealing, of course, with it in detail, but just give you the pillars of the Uncital model law. First of all is granting access by a local court from a foreign representative, so a foreign IP and creditors. The second pillar is a recognition system. The third one is, if there's not any recognition yet, it would be possible to provide relief on a short-term notice. And the fourth pillar is cooperation among courts should be promoted. Next slide, please. Now, recognition is a very specific concept in private international law. So recognition is given to a judgment. So there must always be a judgment in one member state, meaning here for Europe. Under the European Insolvency Regulation, there is no recognition system. Recognition system is working automatically. If a judgment, insolvency judgment, has been opened, the insolvency is opened, for instance, in Germany or in Poland or in Bulgaria or in Spain, they all have their same languages. Many of the Dutch wouldn't understand a word from Bulgaria and Spain. Nevertheless, if a judgment comes to our country as a member state of the EU, with no further formalities, that judgment will produce the same effects in any other member state of the EU as under the law of the state of the opening of the proceedings, unless some 2 or 3 exclusions. But the guideline is we automatically recognize 25 or 27 insolvency proceedings if they come from member states. Of course, you can understand that in October, November, here in Europe, we are discussing about what it means, Brexit, when England and Wales and the other countries will leave the EU and will not be a member state. What sort of recognition system should replace this automatic recognition system? So this is recognition. Next slide. Yes. So the recognition in the model law is given in Article 15, which is in literature seen as the heart of the model law. A foreign representative may apply to the court for recognition of the foreign proceeding in which the foreign representative has been appointed, and you have to send in some documents. Next slide. Then you can get interim relief before the court recognizes the insolvency proceeding. You can ask for certain measures of relief, and you see the list where you can ask for. But upon Article 20, upon recognition of the judge by the foreign proceeding coming to my country, there will be automatic relief that will apply automatically. Next slide, please. Yeah, there you go. So there we go. You can't see my arms. So this is a plane, Virgin Atlantic. So what you see in a very recent case that the U.S. Bankruptcy Court in Southern District of New York, where most of the cases from abroad come to in the U.S., it provides provisional relief based on, was it Article 19, I think, August 7, with regard to Virgin Atlantic. And the court says it was satisfied that Virgin Atlantic had shown its plan under the UK's new Corporate Insolvency and Government Act that was just put in place, I think, some 4 days or weeks earlier. And it is being recognized as a foreign main proceeding. And the judge found that it has been demonstrated that there was a substantial likelihood that the UK restructuring plan would be recognized under Chapter 15, which is a chapter in the US Bankruptcy Code dealing with recognition of foreign insolvency proceedings. The judge extended a restraining order till next to deal with certain matters, and at the end it scheduled full recognition hearings from 4 weeks later. And I think it was 4 or 5 days ago in a Reuters message that the US court indeed has recognized it. I haven't found the case yet. By the way, I haven't searched for it. So you see in a very actual and recent case, the model law works. Please continue, next slide. Now, the model law has been enacted in several countries. And these countries are, and I thank the Gert-Jan Boon who assisted me in writing all those countries' names, but also, more importantly, it is the UK and the US, but also from 2011 to 2015, you see several other countries, Malawi, Mali, Niger, Senegal, Togo. Well, there you go. Uganda, Chile, the Seychelles, and also from 2015 onwards till now, Singapore, Israel, Bahrain, Zimbabwe, Dubai International Financial Center, and Myanmar. Okay, great. Several countries have roughly the same system as in the model law. Again, roughly. Germany, Belgium, and Spain are included. Of course, they don't write to UNCITRAL saying, please list us on the list of model law enacting countries, because they didn't enact the model law, but they were inspired by the same sort of regulation. And a draft in the Netherlands of 2007, again, is already 13 years ago. We worked on it very hard, but nevertheless, the politicians 4 years later said, thank you very much for your work, but it will not be enacted in the Netherlands at that time for reasons unrelated to cross-border insolvency, typically to political knick-knacking. Next slide, please. So how did all those countries enact the legislation, the model law? I'm just providing one snapshot. Several of those countries are very reluctant. First of all, they have been territoriality oriented as of 100 years ago, or many cases, they are not based on common law, but on civil law, like Mexico, Korea, and Japan. They didn't enact the full lot of the model law, the 32 articles. For instance, several courts in countries that are enacting the model law, which allows to recognize a foreign proceeding, but you do not recognize the foreign proceeding when it is manifestly contrary to public policy. Some countries took out the word manifestly, meaning when it is contrary to our public policy, we will not recognize. That means a larger leeway and discretion for a court. In certain countries, the question, of course, is, should we also allow in our proceedings here tax claims from a business in Korea or in Colombia to be dealt with in our country? The general idea is they like to skip the application of tax claims. And certain countries, when enacting the model law, are again reluctant for court-to-court communication, many times because courts and judges are very much nationalized working. They work in the language from Finland or from Japan or from Bolivia, and several courts and several judges do not have English as their second or even as a third language. So it is not easy for a judge, especially when, for instance, in the Netherlands, you have 11 courts competent. Not all courts will have developed language skills. So that's also a sign, if you would enact the model law, which has been done in several countries, we only give jurisdiction, national jurisdiction, to one court. In our proposal in the Netherlands 13 years ago, we said the court in The Hague and not all the other courts. And in other countries, you see the same type of concentration. What you also see as a result of the enactment is that implementation and alignment has to be made with existing laws. For instance, your existing laws, including, is it Article 234 and 235 of the Indian bankruptcy law from 4 years ago, and several other legislation, because you have to mold and create the model law around existing law. And in several cases, it has been demonstrated that although the word from the model law is used, like center of main interest, or recognition, or establishment, the interpretation is not given from an international angle, as Article 8 prescribes, but given the meaning that the term establishment will have in their own country. So there are some queries about the international interpretation on the terms. And in several countries, of course, the infrastructure from the courts is ready for improvement, let me say it this way. When the invitation to speak for you reached me some 4 or 5 weeks ago, I thought, India, isn't it a part of the BRIC countries? Brazil, Russia, India, and China. What are the other countries doing? Brazil, Russia, China, are they doing anything with the model law? I doubt it. I'm not sure. What is France doing? What is Italy doing? What are the Nordic countries doing? So all these countries are on the same level of development, under development, or in a stage of developing, what is the best system for us? It is not a run race that the model law would be applied. Next slide, please. Yes. So if you go to my website, you will see a blog, several blogs. Mind you, I said also in The Hague, which of course didn't make me again a great friend of the politicians. The model law is over 20 years old. Why are you advocating the enactment of an act that is 20 years ago? What are you dealing with the items that were taken into the insolvency regulation from Europe? Items like registration of insolvency decisions, data protection, the unilateral undertaking, meaning that a practitioner in one country asks creditors in another country not to open proceedings over there. How is technology dealing with cross-border communication? Because the rules that Fletcher and I created and Europe has roughly accepted also are from 5 or 8 years ago. And mind you, my dear friend Mr. Fletcher and myself, we are not the most advanced in technology. So other people need to take that onwards. You see the blog mentioned there, I think at the bottom of the slide. Next slide, please. Well, the United Nations is not sitting still. I can read very small letters on the slide on the left-hand side saying model laws. There are new model laws developed. The UNCITRAL model law on enterprise group insolvency, I think it's nearly final. And there is a model law, not the one from 97, on cross-border insolvency and recognizing insolvency proceedings and judgments, but there's a model law related to insolvency-related judgments, for instance, on director's liability. Do you have to recognize director's liability that an English court has said when it comes to India and a person is coming to India? Can you apply such a regulation? Sorry, that's the new model law there. Next slide. Yeah. So I think I'm coming to the final slides for my presentation. My advice would be, maybe if you listen to India, but especially for the Dutch, because as I said in the beginning, we are in the same sort of level of trying to seek a reasonable and practical solution, to first examine the most recent unilateral model laws relating to annex actions and to group insolvencies, the new model law, the 2 new model laws. I bet there is maybe only one country adopting already those model laws. But nevertheless, you can talk to your bureaucratic colleagues in other countries how they will deal with it. I think the Dutch legislator, and again, as I said, maybe in India applies the same, you should investigate the experience on recent practices. The Yukos case, the Brazilian OI case, there was an Indian case on the, what you call it, Sick Employment Act, I think it was, and the recent Jet Air case. Let's listen to the practitioners, what they thought was very welcome to do and what should improve. Speak to your colleagues from Australia, Singapore, New Zealand, you call them, and learn from the obstacles what the legislator met when they are implementing the ideas of UNCITRAL and also amended little parts in their national legislation. Following slide, please. Investigate what the best way would be to give effect to restructuring negotiations and plans. Would it be giving the same effect as an insolvency proceeding? Or should it have the same effect as the Dutch are giving to foreign contracts? Because with the tendency of restructuring, we are probably growing out a little bit of the traditional way of looking at insolvency proceedings. The Dutch said, well, it's not a legislation committee, but an exploration committee. Well, therefore, it's certainly worthwhile to include non-Dutch experts into our small group. We have a group of 4 or 5. And why don't we include someone from England and from Germany, wise experts, to deal with it? Many times the answer in the Netherlands is, well, we cannot speak Dutch anymore. Okay, you do your best and invite them, because we have to learn also from neighboring countries or countries where you have a lot of trade with. And also consider a combination of, why not a part of the model law? Why not bilateral treaties with 1 or 2 countries which are very much in the neighborhood of India, or again from, we don't need it in Europe. Or protocols. The Indian example is already 100 years old, an agreement with practitioners to deal with an international insolvency. You see how the Grand Cayman Court a month ago said, it's very strong for me to have a protocol and forms a basis for me to try to have the insolvency proceedings regulated. Also beyond the model law, because the model law itself tries to include, or also includes as a measure or tool of communication, the use of a protocol. And why not partly the adoption of several of those soft law principles from ALI III? Next slide, please. Yes. Now, this I think is the last slide. The model law doesn't deal with law applicable or applicable law. So an Indian proceeding or the Virgin airline proceeding will be recognized in the US, and there are no rules to deal with, for instance, employment contracts or rights with regard to real estate or IP rights. So there are no applicable substantive law provisions. What you see in the member states in the EU is several countries have applied the model law itself, Poland, Romania, Greece, but many, Spain and the Netherlands, in a draft, said, we take the model law, but also apply the 10 articles that we have on applicable law or substantial law that are in the insolvency regulation, and we expand them also to global cases. As I said earlier, Germany and Belgium build on their own system. Germany says we have a recognition system that is based on what we think is best, but we try to apply the rules from other countries in the way as is described in the insolvency regulation. And then Belgium says, no, we have applied our recognition system in our own way, and we make it part of our code of private international law. So everywhere you see several ways of trying to deal with cross-border insolvency. The message I took when preparing for this lecture was, it's not a run race to have the model law and apply it. You must search for those matters that are advised by practitioners, that works well in other countries, and probably end up with a mix on rules of cross-border insolvency. I think this is my last slide. Thank you for your attention. Is it the last slide? Not sure. Yes, that's my younger brother. So this is my last slide, and I'm open for questions if I know how it works. Thank you, Dr. Shika, for assisting me so very helpfully.
Thank you, Professor Wessels. So participants, you could ask the question in the chat box here. Honestly, I can also give you option of speaking directly to Professor Wessels. And for that, you could just raise your hands and then turn your microphone and video if you wish to. Thank you. So who would like to go first? Yes, somebody has asked that if we could get the slides. I definitely will be sharing with you.
Yeah, that's fine. I thought the slides were sent around, but it's fine to send them around to the participants.
Sure.
And it's also fine if they, after the lecture, they have a remaining question, they send me an email. If you go to, or send an email to you, Dr. Shika, and then you
Sure.
send the email
I'll
to
collate.
me.
Totally. So I can collate all the questions and then pass it on to you, Professor Wessels.
Yeah, no, that's fine.
I see one hand on, and Urvashi. Would you like to go ahead, Urvashi?
Yeah. Hello, Professor Wessels.
Hi, Ms.
Hi.
Shahi.
Yeah. So my question is that what we've seen is that till 2012 or 13, not many countries had adopted the model law. But lately, if we look around 2015 or so, a lot of countries suddenly have started adopting the model law. So why do you think, like, why such a trend? Do you think that the businesses have become more globalized, or we have become more conscious of the problem, or like why for so many years the jurisdictions were not adopting, but suddenly we see a lot of jurisdictions adopting the model law?
Well, I remember from 97 onwards till 2005, it took 8 years for the large countries that are dealing with global business, like the US, and a year later, the UK, to adopt their versions of the model law. So in the beginning, people that were involved in the drafting of the model law were asking, was it worth the effort that we did? So then the larger countries adopted it, including the US and England. On the last 4 or 5 years, I don't think I agree with you that many countries are adopting it. The countries that you see from Africa are all those OHADA countries. So it is OHADA, the regional organization, that says we are going to apply the model law, but UNCITRAL was wise and look at who are all those countries in Africa, and therefore you see a large group. It is also that in the last 4 or 5 years, you see only a few countries adopting the model law. But as I said, if I would go again to The Hague or to Berlin or wherever, and I would ask politicians' attention to my fiancée, which is insolvency law, they would say, I'm happy to meet her, but she's yours. We don't care. So if you are talking about model law and legislation, you are not on the top of their agenda. And therefore, you see, and therefore I think it's wise to continue to further develop soft law instruments. And he was introduced an hour ago to me. Again, we know each other for 20 years already. Dr. Paul Omar has always been very assisting in these type of soft law developing instrument. And as I said, Cayman Islands are there. The High Court in London is there. I didn't mention a New York court referring also to the Fletcher principles of ALI, III, saying, and also the High Court, for instance, in London, saying, we don't have any treaty or convention. Let's look at what larger group of lawyers says this is the best way to go forward. And both courts in New York and in London said, we take this principle to further develop our thoughts on. So soft law is becoming slowly, but not doubtfully, a player in the global field.
Thank you so much.
Thank you, Professor Wessels. We have Pulkit. Pulkit, would you like to go next?
Yes, I'd love to. Professor Wessels, I don't know what time it is, but it's afternoon here, so don't mind me saying good afternoon. My question is essentially twofold. The first part of the question is essentially whether, sorry, are you unable to hear me? I can see you gesture, but I might not be clear. Can you hear me, Professor Wessels?
Not very well, but my ears, not my face, but my ears are getting older.
Let me try and change.
Is it any better now?
Yes.
Ah, excellent. Right. Great. My question is essentially twofold. The first part of the question is, do you have a view on whether there should be cross-border recognition of pre-insolvency proceedings, such as the light touch administrations and so on? And a related question, which goes a step further. So in the case of, in Altair's case, the Cayman court held off, while the Hong Kong court, who was ostensibly holding preliminary jurisdiction, or primary jurisdiction rather, was entertaining a petition for winding up. Do you think that they were right in holding off at that point? Do you think the Cayman court was right to hold off, where they ostensibly had a secondary jurisdiction?
This is typically an answer from someone that walked around for 40 years. I cannot say whether a court is right or wrong. I've been a judge for 25 years, so I'm not reluctant to give an opinion, but I cannot decide on it without having seen all the documents in the case. So what I took is from Reuters and from a newsletter. So I cannot say whether a court was right or wrong to deal with a certain matter. The first question
we can put it in
go ahead.
No,
go ahead.
I was just thinking about policy. I was just thinking about as a policy decision that a court in which may ostensibly be in a secondary jurisdiction should hold off on a creditor's petition, where another court is still entertaining a petition which may have primary jurisdiction, so it has not actually initiated proceedings. So that's why I said the two questions were connected. One is where there are pre-insolvency proceedings already initiated, and other cases where there are no proceedings, but still a court is held off. That was more
well, in general,
question.
Your voice is gone again, sorry. But in generally, I would be in favor of one court holding off their decision on whatsoever, if you know that the other court is dealing with a similar or a likewise matter. I remember in Europe a case with regard to Ben Q, a Taiwanese company, very known at that time as a sponsor of the soccer shirts of Real Madrid. But there were cases between the Netherlands and Germany, and there, because the petitioners told the courts that in the other jurisdiction a proceeding had just started, in the Netherlands just started, the German court said also in its later argumentation of its judgment that they hold off their decision for 4 or 5 weeks to await what the answer would be from the Dutch court. I think that's also a matter of probably judicial courtesy, that if you know that another court is dealing with it, that most probably will also involve your own decision. I think it's respectful, and if it is practical, you know, unless there are short-term decisions needed, but it is respectful and wise to wait, because you are dealing with a cross-border globalized business, and the globalized business is dealing with all those nitty-gritty small courts in all those countries. And many of the judges I know, they understand that they are sovereign and they remain sovereign to decide, but it is wise to be open what happens outside of your domestic national framework. Your first question is a very interesting one. I'm not sure whether it's on the agenda. I will repeat the question. In many countries you see pre-insolvency type of proceedings, restructuring type of proceedings. The Dutch call it homologation, so approval of a collective private agreement, or pre-pack type of rules. In England, there are known a pre-pack. In the Netherlands, we use the term pre-pack, but we mean something different. But every time there is the idea, is this an insolvency proceeding which would fit in the definition of Article 1 or 2 of the model law, or is it much more broader? And I think at the end of the day, you will probably have to have another model law dealing with combinations of parts are formal type of insolvency proceeding. Major parts will be more contractual. In Europe, we deal also with the so-called Rome Convention on contractual obligations. There you may have to question whether, when there is a private arrangement between a company and creditors from 4 different countries, and the private arrangement is approved by the Dutch court, is the court approving a collective multi-party contract, or is the court opening a proceeding which is based on those contracts? So this is a matter of definition. And Mr. Deora, Pulkit Deora, I'm very much honored if you would write me a 20 pages paper that deals with this question. I think you will be the first one, and I will make sure that your paper will be published.
Thank you very much.
Okay.
Really appreciate it. Thank you.
So the paper is due tomorrow.
I've got a few hearings coming up, but I will write something and send you. Nevertheless.
Yeah, that's and by the way, the time difference between Amsterdam,
four and a half or 3.5 now.
It's 3.5, and I was wondering, because when I first called Dr. Shika, I said, well, maybe they are on 6-hour difference, but they are on 3.5.
Yes. We don't have daylight saving time. You see, we don't have daylight saving, so so some part of the year it's 4.5, and some part of the year it's 3.5. Okay. Which is why I wasn't sure whether it was before 12 or after 12.
Okay. All right. Thank you very much.
Yeah. Thank you, Pulkit. Any other questions from the audience? We have one from Akriti Sood. Akriti, would you like to speak, or should I read out your question? Uh, so the question is, what pressing changes, according to you, should be made in the model law to cope up with today's cross-border insolvency problems?
Well, thank you. The examples I gave are related to the insolvency regulation of some 3 or 4 years ago in Europe. The insolvency items that should be regulated in the model law should also reflect the heartbeat of present global business. For instance, technology. For instance, protection of privacy and data. That hasn't been taken into account in 1997, for instance. But also the idea that there will be businesses much more globally, but where you hardly can see where it is located because the business is done via the machine, via technology. So maybe some of the concepts that we are using, like the center of main interest, is very important to allocate jurisdiction to. Where is the center of main interest with an E-type of company that deals only with technology and doesn't have a store or doesn't have. So this is typically those new items that should be taken into account. And I'm not sure, maybe Dr. Omar is, whether in UNCITRAL there's some sort of forward-thinking group unrelated to politics and unrelated to the present model law, just with an open mind and say, well, if we would have cross-border insolvency nowadays, what would be the topics of interest just to think about and discuss?
So I know that Professor Rebecca Parry is working in this domain. I mean, she intends to work on insolvency of cloud technology. So I think some professors, some scholars across the globe, they are working in this area. But I don't think from the UNICITRAL standpoint, we have an answer to that. So I'm just mindful of the time that we started at 3:30 and the event is to end at 5, stretch by 5 o'clock at max. And of course, Professor Wessels should have pleasant experience coming and speaking to us and not feel that he's forced into this conversation. So can I just ask for the last question for the day, and the rest of the questions I'm going to collate from all of you and pass it on to him. Ishan, would you like to go next?
Sure, ma'am, thank you. Am I audible?
Yes, please go ahead.
And thank you, sir, for your time. So I just wanted to understand, how do you reconcile between different jurisdictions who treat their stakeholders differently? And in that case, how do you push for a reciprocity clause?
Well, thank you for your question. The first one is stakeholders. I've dealt with issues on so-called stakeholders many times. But a stakeholder is not a legal concept. So are we talking about creditors, shareholders, employees, etc.? So if we are dealing, for instance, with shareholders, I would start a comparative survey how in the Netherlands, in insolvency matters, we will deal with foreign shareholders. How will it be done in Norway? How will it be done in Portugal? How will it be done in several others? And then try to distill a rule whether it is advisable that in insolvency situations, the voting right cannot be applied on shares, or only a certain matter, or so. Stakeholders in general as a concept doesn't work for me as a lawyer. Your second question escaped me. Sorry.
So it
Mr.
was with regard to reciprocity.
Yeah.
So it was with regard to reciprocity. Yeah.
Yes. Well, I try to, limit myself um, as I am always respectful for the audience. But my main concern is that reciprocity is used to solve problems or related to issues that are not related to any bankruptcy issue. For instance, you can imagine that reciprocity would work rather well in a case where, for instance, the Netherlands is rather in political non-speaking terms with another country. Presently, Russia is a case, could be a case like that. Would that be an argument not to recognize a Russian proceeding, insolvency proceeding? You could also say, we recognize the Russian proceeding as we did in Yukos, but it took 8 or 10 years to decide that we wouldn't recognize it because it was manifestly against public policy based on certain matters that are related to Russia. So reciprocity means in advance you're closing the door. And I wonder whether when you deal with cross-border and globalized business, just slamming the door, if someone knocks on it, you're totally out. You better can deal with the problem, the proceeding, listening to what the proceeding is asking for, and when the proceedings or the effects of the proceeding do not have any effect on public policy in your own country, you can further deal with it. So I think that reciprocity is a standard, a term, a concept that you cannot use when you're dealing with global business or insolvency of global business. Okay, thank you very much.
Yeah, thank you, Ishan.
And I see or speak you next time.
Yeah, so there are more questions, and if you allow, Professor Wessels, should we mail it to you?
Yeah, if you send me, not too much, I hope, or combine them, and I will try to answer them the next week or two, some 10 days from now.
Yeah. So even I had a question, but I think keep considering the time in mind, I'm gonna mail it to you as well.
Yes.
And so thank you so much, Professor Wessels, for joining us today. I've only read your scholarship, and today it was great honor to hear you speak in person. And I'd like to thank you on behalf of IICA and Center for Insolvency and Bankruptcy, and all the audience who gathered with us today to listen to this fantastic talk given by Professor Wessels. And we will be putting on the recorded version on our YouTube channel. Please feel free to write to me if you have any more questions, and I'm gonna collate all the questions, make it short and crisp, and send it to Professor Wessels for his comments. Thank you so much, everyone. Special thanks to Urvashi, who's who's helping us. And yes, cheers to Urvashi and Professor Wessels. Have a very good evening to you, and we'll be in touch.
Okay, thank you very much. And I hear a lot of applause coming out of the machine. So thank you, and I hope to see you once again. Bye-bye.
Thank you. Bye-bye.